Yeah, welcome to the second session on software and law, and we're going to look at mostly IP, trade secrets. We're going to look at the, still quite introductory. There was quite a lot in the reading list, quite a lot of new concepts, especially for those of you who haven't done IP. But we're going to go through them in the next few weeks, so don't worry too much. It's just, at this stage, an introduction on the IP things. First, some housekeeping. First, apologies for the grammar in session 2 questions. So some of you might have seen that the questions in the handouts were not properly written, so apologies for that. I uploaded the wrong version of the handout. Class rep, we have a liaison student, Natasha. Yes, thank you for volunteering. And so that's all good. One word also for if you are going to be absent from the seminar, which kind of happens quite a lot at this stage, at this time of the year where people get sick and all that. So just send me an email beforehand and put the undergrad office in copy of the email. And then if you have a valid reason why you can't come, then I'll put you as excused in the register. Okay, when I put the register on. Okay. So in this seminar, we're going to look at IP rights in general. What type of IP rights might be relevant to the protection of software. We're going to look at trade secrets, and then we're going to start digging in a bit deeper in the copyright in the software. Go deeper in the basics of copyright protection and how they might apply to software, and that's what we're going to study in more detail next week when we look at infringement of copyright, what is protectable, what is not. Hopefully we've done enough introduction in this session so that the next session should be easier to dig in. I'm going to also give some tips on research and essay writing. So throughout the semester I'll give some info about what I expect in terms of the final essay, how to do proper research, how to manage your research, how to cite sources, because some of you might be very familiar with the process, and for some of you the way we do it here might be new. So this time, if we have time, I'll look into the research side of things, how to manage your resources. Okay, so intellectual property and software. We start with the first question I ask you is, what are IP rights? What is the rationale behind IP rights? What is the aim of IP rights? What do we have IP rights? So, does anybody want to start? What is the purpose of IP right in general? When you cover all the IP rights, what are they aiming to do? First question. Why do we call it intellectual property and not just, by opposition to property? Where does it come from?
I think the main sort of three were copyright, trademarks and patents, and then there was maybe sort of a few other extras in there as well. So their intellectual copyrights are sort of the rights given to people over their creations, sort of giving the creator an exclusive right over sort of what they've made for a certain period of time. So the reason that they have this it was sort of like one of the readings that it's like the development role of modern society to keep a protection of the incentive innovation reward cycle. So it's like people are actually getting recognised for their works and they're able to like benefit from them and then they go into like the public domain, so other people can build on them as well.
Yeah, so that's the end of the, once the protection has finished, yeah, it goes into the public domain. Okay, so you've identified some of the main IP rights, so I mean, I've listed them there, so copyright, trademarks, patents, design rights, related rights. We're going to see breach of confidence, trade secrets, which are a bit potentially different from the other ones. I mean, there's a question about whether trade secrets can be classified as IP rights. So these are the main ones. I mean, all of them. So the rationale for IP. In what way are they different? So it's intellectual property. In what way intellectual property is different from real property? What are we trying? What is the challenge in trying to protect intellectual property compared to real property, compared to land, compared to buildings, compared to other types of property? Yeah.
Is it that a lot of the time in intellectual property there isn't actually a thing? There's like a method or an idea.
Method, idea. How is it? How do you call that? The fact that there's not a thing, an object like that. That's a property on that, real property. It's the notion of protecting
non-corporeal.
Yeah, non-corporeal. The other term is intangibles. Okay, tangible property. And so why do we need to have that protection of intangibles? What's the reason behind having that type of protection? Because it's kind of a newish thing. That is, we have rules, and societies have been able to develop with rules about who owns what type of property, land, who is allowed to be in one space. Why do we need to protect IP? You've alluded to that because
maybe to encourage innovation.
Okay, so and so what would be the? Can you talk me through the thinking between this? So it's called the incentive theory, yeah. So the idea is, if you don't protect intellectual property, right, the inventors, the creators, the writers won't be able to make money. And if they don't make money, then they won't create. And if they don't create, that's not good for society. Okay? So that's the incentive theory. So, in the reading they do mention it a bit. But there's another theory. I don't know if you've been exposed to it in the reading. Probably not, but there's another theory as to why intellectual property needs to be protected. And it depends where you come from in the world. You might be more familiar with,
Could it be like the moral aspects, or?
Yeah. Moral aspects, meaning?
Like you have the right to your own work, so nobody copies it.
And what can you link that to? I mean, why is it important to, whether there's an economic incentive or not? Why is it important anyway to protect what an inventor invents, what a writer? Yeah.
Because the creators put in their labor and personality to intellectually create the work of art.
Yeah.
So this creates a right held by them to have their creation protected from exploitation of others and the right to control sort of their fruits of labor.
Yes, so the fruit of labor is still a bit of an incentive theory, but so basically you have two theories that are kind of conflict to some extent, but so you have the incentive theory, which is the theory that is the most dominant in the UK, US, Commonwealth countries, and then you have a human rights theory, that is that copyright and others should be protected as an end, okay, not as a means to do something else, but it's because the idea is because the creator puts so much of his or her personality into creating that product, that piece of art, let's say, that it needs to be protected as such. Okay, so that's a bit of a different attitude. Okay, so you'll see in the European context, it's more a human rights approach with moral rights and all that stuff. Okay, France, Germany, continental Europe, and also, I mean, many countries have this approach, that is, we need to protect it because it's the personality, the human right of the creator, and you also have an economic approach, incentive approach, which is more US, UK. Okay. Just a quick word to say that in the history of IP rights, the UK has played a really critical role in creating the new modern IP rights, so around the 17th century, 18th century, so the UK, both in terms of copyright, modern copyright law, modern-ish copyright law, patent law, trademarks, the UK has been very significant, and for a long time this kind of need to protect IP rights has been very European-centric, right? And it has expanded throughout the world through, I'm going to explain how. So started in Europe, then the US is a big proponent of IP rights, and then it has spread across the world. Okay, the international context, we've mentioned that before, previous. So you have two main instruments, two main bodies that devise rules. So the World Intellectual Property Organization, it's a UN body. As you can see, it started very early-ish. Okay, so in the 19th century, you have some international agreements about IP. At the time, one of the main issues was to get the Swiss to abide by the French and the Germans' patent laws, and then for a long time the issue was to get the US to abide by copyright law, because the US would basically import stuff from Britain and not pay the authors. Okay, and then it's been to get China to comply with IP laws, and that was done by the World Trade Organization and TRIPS in '94. Very quick overview of the spread of IP laws. Okay. At European level, so as we mentioned, the EU dimension is very important, the European dimension in general, but also the EU dimension is important in the world of IP, including in the UK, even though the UK has left the EU. So the IP laws are protected as a fundamental right at EU level. Okay, so you have the Charter of Fundamental Rights, Article 17 protects property, 17.1 protects property, and 17.2 protects intellectual property. And then you have also unitary rights, that is, if you have European trademark, it is valid across the EU, okay? Because otherwise, if you don't have, you can choose either to have a trademark, let's say, in the UK, and then you can say, I want a trademark, this trademark protected in Germany and in Turkey. Well, Turkey is not part of the EU, wrong example, but Spain. Or you can have your trademark as a EU trademark, and then it's protected all across the EU. Okay, so you have the system where you have rights that are, IP rights that are now valid across the EU. Okay, so you have trademarks, design, and now also patents. And as you've seen in the reading material, you have a lot of case law from the ECJ to explain what the directives mean. So you have harmonization of rules via directives and regulations, and then the case law from the ECJ. Last thing also we've mentioned European Convention of Human Rights, which is not a EU institution, and that's whatever happens in terms of case law, that will be also directly relevant to the UK, because the UK is part of the ECHR and the Council of Europe more broadly. Okay. So the most relevant framework for the next few sections in the UK is the Copyright Design and Patent. I didn't put the patent. Sorry. Copyright and Design and Patent Act, and the Trademark Act, and the CDPA, Trademark Act, and Patent Act. Okay, so that's you'll see when we go into the case law, there will be references to those statutes. So I asked you to look at the different IP rights and to compare them, right? To compare them in what are the strengths, what is their purpose, what do they aim to deliver, and that to understand which ones is most likely to be applicable to software. So what you need to look at in those rights is what they aim to protect, how do you obtain protection, the strength of the protection, the length of the protection, so we've mentioned that, exception and limits, and whether it's statute-based or case law-based rights. Most of them now are all mostly statute. Okay, so we're going to go together and try to do, let's see. So let's try to do it live together. So copyright, what is the subject matter of copyright? What do you think copyright aims for? And try to protect. Yeah.
Protected sort of written works, but also protects like musical and theatrical performances, photographs and recordings, that sort of thing. So it gives the copyright holder an exclusive right to be able to copy work, issue copies of their work, to rent or lend their work to the public, perform, show or play the work in public, and to communicate the work to the public, and then make adaptations of the work as well. So ultimately it's just having like the control to the person who's created it or the people who have created it.
Yeah, so that kind of control that the IP right owners or the copyright owner has, and you find it across all the IP rights, it's kind of a tenets, is that you get protection for an IP right, and then that allows you have the exclusive rights to exploit that invention or that work. Okay, so copyright, so more the arts, entertainment, books, music. What do you need to do to get copyright protection? So what is the criteria for subsistence of the right? Yeah.
There should be originality and fixation.
Originality and fixation, yeah, we're going to detail that a bit later on. what else do you need to do to show, so originality, fixation, that's what some of the key things. The other column there, no, row, registration. Yeah?
It arises automatically.
Yes, automatically, so you don't need to register the right. Okay, so that's a big point of difference between the copyright and trademarks and patents and design what you can have unregistered design rights. But that's a big point of difference. Okay, so do you guys have produced copyrighted works? Do you produce? Is any one of you? I was going to say granted. Have any one of you been, or is any one of you in possession of a copyright on stuff that they've done? Yeah?
Maybe when you write or essay.
Yes, so the essay, okay, and if anything you write, right, provided it's original, so we're going to talk about the originality of essays in the plagiarism bit of the course. But yes, if it's original, it's fixed on a piece of paper, or actually on a computer, that works. Two, what else? So essays, so you all have the copyright on your essays. What other stuff can you get protection on?
Pictures you take?
Sorry?
Pictures that you take?
Yes, pictures. So almost all of the pictures that you take are protected by default by copyright. Okay, so you are copyright owners of that. What else could be protected? So, I mean, the essay is kind of a substantial piece of work, but what other, more trivial stuff can be protected? Yeah?
Maybe anything original on the social network.
Yeah? Anything, or not anything, but provided, but most things that you write on social network, in your text, SMS, okay, that is granted protection provided you reach the threshold of originality, which is, we're going to see, quite low. But basically, copyright is very easy to get. Right? So that's what we're getting at. How long does it last for?
I think it's 70 years, but it dies with the person.
So it's 70 years, so that's the time frame. But 70 years from when? Yeah?
The end of the year for the person's death.
So it's all the way, so it's 70 years. It lasts 70 years after the death of the person. So let's say you're 20, you create a piece of work, and you live until 90. So you have 70 years, that's protected for 70 years, and then another 70 after you die. So 140 years, right? 40 years, so very long protection. Trademarks. So let's see if working in subject matter. Okay, no, we'll do trademarks. Okay, so let's keep that in mind. I'll do copyright first, and then trademarks, and then patents. Okay, so artistic, musical, dramatic, and literary works, sound recordings, film, broadcast. So that's what it's meant to be protecting. I have a question for you. We're gonna try that. Let's see. So I switch. So. Let's see. There. 2. Okay, let's try to get some people in. So I have a question about copyrighted works that also links to free software or computer programs. It's also for me a way to test the different type of questions that you can ask with this platform, which I still need to be familiar with. So, 16, yeah. Okay, 18, yeah, we're about 19. 20, yeah. Okay, so good. So, question about cultural products, copyrighted entertainment products, which, when you think about stuff coming from Scotland, so copyrighted works coming from Scotland that are famous the world over, and yeah, so you should be able to type anything, right? If I've set it up properly. Can you think about which IP property coming from Scotland is famous the world over? So that is when I put my slides up in the LLM class where there's nobody from Scotland, nobody from the UK. If I show them that piece of IP, copyrighted work, they know what it is. So basically it's been made. Both of them, I can think of two that have been made here. In this city actually. And I'm looking for stuff also that I haven't thought of. And one of them is related to software. One of them is software-based computer program software in a broad sense, but it's something that is one of the biggest cultural products in history. Also, I'm really interested to see. I mean, you can cheat and have I asked Bing, because I try now. I go on Bing and ChatGPT and try to test the question I ask, also for the essays, and see whether the AI is good. But I'm happy for you to cheat and use them now. Okay, so we have 13 answers, 14. So that's okay. So let's have a look. Okay. Result list, word cloud. Okay, so if you click that. Yeah. Grand Theft Auto, yes. Buffalo is from here. I didn't know. Is it? Single malt whiskey, okay. We're gonna Skyscanner, oh yes, that's a company. Harry, yeah, we have Harry Potter, Rockstar, Bagpipes, yes. The tattoo, yeah, actually I haven't thought about that. That's something quite significant. Okay, video games, yes, so let's see that there. So I had two in mind. So the Harry Potter series, okay. J.K. Rowling, people familiar familiar with that. So written here, and the other one, yes, the Grand Theft Auto series, which, I mean, the last one was released 10 years ago now, more, 2013, Grand Theft Auto 5. Where was it produced?
Dundee.
No, the first ones were in Dundee, and then they moved here. So
Just next to Hollywood, is it not?
yeah, Rockstar North, sorry. So just 10-minute walk from here. That's where they produced GTA 5 and GTA 6 will be. Well, we don't know exactly where it's been produced, but it's likely that Rockstar North will have an impact on that. So. Or a role in there. So yes, you can walk by. They have a very fancy building, and when Red Dead Redemption was out, they had a fancy poster or feature on their building. So yes, bagpipes, okay, and Scottish whiskey. We'll mention it later. Okay, so trademarks. We'll be quicker on trademarks. So it's a protected sign that can distinguish different brands. In terms of comparing that to copyright, how easy is it to get trademarks? What do you need to show to get, or to do to get trademarks? Yeah?
You have to register it, but before you register, you have to make sure that it doesn't fall subject to absolute and relative grounds for refusal, as stated in Section 3 and Section 5 of the Trademark Act.
Yes, and what would be, do you have some examples of those kind of ground for refusal?
Like, for example, an absolute ground for refusal, is that the mark is devoid of any distinctive character. So they have to be significantly different from other marks that are registered publicly.
Yes, and so and it all depends also in which type of goods you want. So, for instance, if you were to say you wanted to register Apple for a grocery store, the office would say, well, no, it's too generic. However, if you want to register Apple for computers, then it's distinctive enough that it will be approved. There are also other grounds for refusal, and it sometimes links to morality issues. So it's very difficult to, for instance, register names that are linked with religions. Okay, so you can't register. Should you want to, it might be a bit difficult, or things that are linked to drugs or violence. So there are rules as to what you can or cannot register. So you have to get approval, and what comes with that approval? What is involved in the registration process? Yeah?
The ownership of rights.
Okay, you get the ownership, and what else is significant from a business point of view or a cost point of view compared to copyright? Yeah.
So a lot of companies spend on advertising, and they want to make sure that people associate their brands with that specific logo or item, and it kind of helps preserve like advertising costs and make sure that they get.
Yes. So so it's a lot of money first to register. Okay, so you have to pay the IP office to get the registration. Okay, you have to keep on paying the registration, but if you do that, you can get protection forever, right? As long as you keep using the trademark and you keep paying the fees, you keep on getting the protection. Now, there's something you want to avoid happening is your mark becoming generic. So that is to become a word for a thing. So Google is quite keen to make sure that Googling, the word to to Google something doesn't become a generic and that they lose the trademark. So if it becomes not distinctive enough, well, we won't go into the. Basically, there's a risk if your marks become too famous that you can lose it because it becomes a generic term to describe an action or a product in general. So there's a lot of money going to that. But also, as you're right, to keep a lot of money is invested in the trademarks to make them famous, to make them relevant. So a lot of money rides on trademarks. Okay, so some famous trademarks, but yeah, just quick. I mean, those are quite old, but how many of those can you recognize? I mean, it's links also to it's just to see how we are, how the money spent, whether it's well spent or not. This one, okay, a bit more difficult, not necessarily difficult, this one. Rolex, okay, it's good, really good. So Adidas, BP, this one a bit more tricky.
Is that NVIDIA?
Yeah, NVIDIA, so graphics card. This name, if you do anything to do with AI, they're the ones who create the chips that are used in video games and AI. Michelin, HSBC, this one, Chanel. Okay, so good. All this money has been well spent by the different brands. Okay, one last one. What's the last one? Ford, but not really Ford. So that's a parody or satire of Ford. Is that trademark infringement? You all, or most of you, thought Ford. So can Ford say, oh, this is a problem, this is an infringement, because the consumers thought it was Ford, whereas it's not Ford? Is that a problem? Is that not a problem? Should it be a problem? Or what is the trade-off there? Why is that allowed? Or should that be allowed to prosper?
Would that be like passing off?
Passing off, but are you confused as a consumer as to, let's say you buy a T-shirt with that on? Yeah.
Well, it depends on the use. Like a T-shirt, it's what you're buying, probably permissible, but if you put that on some sort of machine,
A car, yeah, on a car maybe. Yeah, so this in all of the IP laws, especially on copyright trademarks, you have exceptions. So you are allowed to use some of the features of the mark or the copyright up to a point, but you have breathing room in the system to prevent you from. It's not an absolute power basically, but you have when you get an IP right. Yeah, there are limits to it. We're going to see that in the copyright debate, but just to in the trademark field, there is a parody exception. Most famously in the US, there's famous cases of parody exception. One of them being the Barbie girl Aqua song. Mattel sued the makers of the publishers of the Barbie girl song, saying they were infringing their trademarks, and the Supreme Court said no, actually it's fine, it's within the parody exception. So you have limits to what you can do with copyright. Okay, Scottish brands. Yeah, I had a question on WCAG, but we can maybe just try this one. So Ruffalo, I didn't remember it was Scottish. So famous brands, Scottish brands are the most famous. They are mostly from one industry. I think of, but seems here for. Okay, Town, Johnny Walker, yes, Turnouts. Okay, Iron Brew. Okay, that's this. Oh yeah, keep on changing this. Oh, it's fancy. Okay, Highland Spring. Okay, yes. Quaker Celtic. Okay. Oh yeah, I didn't think about the football thing. Yes. Scottish water. Now think about the again, I'm trying to think of the brands that have most reach outside of the of Scotland or the UK, Scotsrail. Let me see. So I had this one, Irish Street, which none of you know. People are not familiar a bit. Okay, and otherwise, yes, I think in terms of global reach brand, it's all whiskey, right? So all the whiskey, and with possibly the Johnny Walker mark, maybe the most famous one, I would say, of all the whiskies. Yes, so significant one. In terms of software, so trademarks is something you come across any kind of business. Most businesses have protected trademarks. This is something, in software, even in entertainment, any kind of business. It's probably the IP right which is the most commonly used and the most, in terms of business, most businesses have a portfolio of trademarks. Now in software, there is one famous example there's several examples as to why trademarks does matter. So you've set up you've come up with a new service, a new type of software. It's all ready to go. You put it in the market, and then there's a problem with the trademark that jeopardizes the whole enterprise. So the example I've put in the reading list, further reading list, it's this one links to SkyDrive. Has anybody heard of SkyDrive? Does that look familiar to something you might be familiar with in the field of computing, software services? Yeah? OneDrive, yes. And why is OneDrive called OneDrive and not SkyDrive? So SkyDrive was the initial name that Microsoft had given to the service, right? And there was an issue by a British company raised an issue and said, well, you can't have SkyDrive because it creates confusion amongst consumer with my service. Which service do you think would be likely to object to the use of SkyDrive? Which kind of big company in the UK would be
Sky?
Yeah, Sky, BSkyB, the television company. Satellite, okay, so you have the case BSkyB v Microsoft 10 years ago now, and basically the court said, yeah, no, there is a risk of confusion. And it was quite interesting because the BSkyB was able to show transcript of people phoning them. So they had an issue with their SkyDrive, right? So you download one SkyDrive, there's an issue, and they would phone BSkyB and say, your software is not working, we have an issue. So clearly there was a confusion amongst the consumer about who was at the origin of the product. And so BSkyB was able to say, this is infringement on our Sky trademarks. And so Microsoft worldwide had to change. I think there was also an issue in Germany, again with SkyDrive, because somebody had a prior trademark. Okay, so they had to change the whole product worldwide to OneDrive. Okay, so you'll see trademarks popping in the field of software, trademark issue, trademark trademarks, litigation. We're going to mention open source software quite a bit. There's often also issues linked with the use of the trademark of open source software. So very significant. Okay, so we're going to do patents later on. Let's take a break, 10-minute break, it's 12. Yes, let's do that. Start with the register. Okay, so do it slowly. Lots of people come back in. Alexandre, Chanley, Erin, yes, she's here. Samuel, Ingrid, Gemma. Gemma, no, she's not in. You're not Gemma, no. So, Skylar, Katrina, Jennifer, no. Alex, Patricia.
Here.
Is it the way you went up there? Yes, Patricia. Natasha, here. Ewan, here. Ellie.
Here.
Yeah. Stephanie. Erin, the other Erin Morrison. So Louis. Zalan? No. Muskan? Yeah. Tanya? Victor? Don?
Here.
Nathan? James? Yadi? 11 is not here. Okay. That's an example of one of the first patents. What is the invention being protected by this patent? So in this design, there's, what is the, can you guess the invention that was protected. So patents are there to protect invention, non-obvious invention that are novel and able of being industrially applied. What's that? And yes, on. Sorry?
A vacuum.
Yes, it's the first vacuum cleaner. Okay, 1869. Okay, so patents. Granted in the patent office. What's the? Oops, sorry. Compared to the other two, what do you need to do to get patent protection, and why is that relevant to the discussion about software? We're going to dig into patentability of software a bit more later, but what do you need to show? What do you need to do to get protection for patents? Yeah.
You need to show that it's new, that it has an inventive step, that it's capable of industrial application, and it's not one of the excluded matters.
Yes, and amongst the excluded matters, you have algorithm and stuff that would be kind of tied in with computer and software. So the exclusion patents, but generally speaking, on the other requirements. How would you compare those to that for copyright and trademarks? Is it harder to get, easier to get? Yeah, a lot harder to get, right? Patent costs are a lot higher than trademarks, so you have to pay your patent fees. If you want to, of course, the more jurisdiction you want to have protection in, the more patents rights you have to buy. For each jurisdiction, you have to go through the same process of application. So it's very time consuming, it's very expensive. What's the trade-off in that, or what's the benefit that comes out with a patent protection? Yeah?
Prevent any other companies or people selling like a product or similar in the process, which is the subject of the patent, even if they developed it themselves and created it and came up with the idea and that sort of thing.
Yes, so it's a lot stronger protection, right? So in copyright, somebody might have a very similar idea as you, in a different country, and produce something that looks quite similar, and that would be fine, unless you can prove copyright infringement. So that is that the other person knew about your work and copied it, which is harder to prove. Whereas with patents, basically, once you've got the patent protection, you are protected against people coming up with a similar invention. Okay, so it's quite close to protecting the idea behind the invention. Not quite exactly, but basically it's a very strong protection. It only lasts for 20 years, so it's hard to get. It's very strong, but it's very short. Okay, and yes. So, which type of IP is the most valuable to a business? Can you answer that question? What would you think is the most valuable IP right for any business to get? Yeah.
In terms of business in general, I think trademark, because a part of the business is their brand, and with their brand you have your network of customers and goodwill and stuff like that. So I think it's the most valuable.
Most valuable, or is the most it's the one that you can't really do without, whichever business you're in. In terms of, this question is very generic, and the normal answer to that question is a very lawyer answer. When you ask a lawyer a question, what is the normal standard answer to any type of question? Yeah?
depends.
Yeah, it depends. Okay, so it depends on the business. It depends on, if you are in the arts, probably copyright is more valuable. But yes, you're right. The trademark is always there, almost always. And then depending on your business, if you are in pharmaceuticals, the one you want is patents, right? Patent and trademarks. I should have given the example actually of, because the problem with patents is very short, okay? So you can build your brand upon an invention. The invention becomes part of the public domain, but the brand remains, okay? And then you can use the brand to keep on going with the business and selling stuff that is in the public domain. One example of that is what Lego did. So Lego had a patent on their bricks, right? The patent drops, but they still, so you can now do copies of the Lego brick, okay? But whilst the patent was there, they grew the business, then they grew the brand, then they used cross-licensing with Disney and others to maintain a strong presence, even though the core of the business, what started up, the patented invention, the bricks are not protected by patents anymore. Okay, do I have the time? 10 minutes. Are people familiar with this show? What's this show? And they are still those two guys. These two. I don't know whether I have time to pass 10 minutes. Do you know this show? Dragon's Den. It's a business show about people coming up with business idea in front of the panel. And it was Shark Tank in the US and in Australia. They come up with an idea about doing a business. They try to convince those guys that this is a good business idea. And then if those guys are convinced, then they buy a share in the business. And then whatever money the business makes, then they get a share. So they come up with, it's like almost like a startup kind of thing, angel investors. And quite often, so it's a show that has been going on for at least 15 years or 20 years in the UK. It started in Japan 25 years ago, so it's quite popular. There's still a series. There's a series happening now as we speak. I haven't watched it in some time. But a lot of the discussion when people come up with a business idea is what type of intellectual property you have on the stuff you want to sell, right? So there's always that discussion, especially at the start of the show, so 10 years ago. Now people are more familiar with it. I have a clip, it lasts 10 minutes. Don't know if we have, do you want to watch it? No, a little, yeah. Try a little clip on the importance of IP. Let's see, let's try. So the thing is, which IP rights, so I'm going to ask you which IP rights are being discussed in this show. So one of the dragons is Duncan Bannatyne, so he's Scottish, so you'll figure it out by his accent. And they have a discussion about the IP dimension. Often, those two would compete about discussion about the IP. Yes, so we'll see. We'll try to make it work. Pay attention to the IP discussion. So I'll see there if it works. No, it doesn't work. The sound doesn't work here, but it's okay because I have it on. What's going on there? See. Oh, so it works there. So see.
Hi, my name's Clay O'Shea, and I'm here for £50,000 investment with 25% share in my invention, AbsPack. Now, Dragons, I don't come here, I'm not got the best business brain. What I do feel is that I'm a decent idea. I've got a really good idea. And with my beautiful idea and your beautiful brains, I feel that there's no reason why AbsPack can't become the best bit of kit in the UK, maybe even the world. AbsPack is simple. It's so simple, you wouldn't even know I've got it on. So look, here you have a normal spine. This is quite impressive coming from me, right? It's called a lumbar spine, that. It's the natural curve in your spine. Most sit-ups are done on a flat back. That puts stress on your lumbar spine, degenerates your lower discs, and wears out your facet joints. AbsPack fits perfectly into that curve. So now, I'm going to give you a little demonstration of how not to do sit-up. Many times in the gym, you see the old neck moving. That's not a sit-up, that's a neck up. Oh, neck's gone, neck's gone. So now, look at this. I'm in a perfect position. I can sit and watch TV like that. The only thing that's moving on me now is my abs. There's loads of exercises that I've made. There, it's just my abs. This here. My neck's not moving, just my abs. No chance of any trouble. Now, once you do AbsPack, you'll never turn back. Please, help me.
A passionate plea ends this whirlwind pitch from North Londoner Clay O'Shea. He needs a £50,000 investment in his portable muscle building device and is offering 25% of his company. Theo Paphitis just looks bemused.
Okay, we all understand now what it does. What do you do?
Well, I run a small gym over in Notting Hill.
Do you make a living at the gym?
Yeah, I keep it small, I don't advertise. With mine, you only get in if you know someone. You know, like Fight Club. You don't talk about Fight Club. I've got a great life, no matter what. I feel privileged, you know?
Talk me through your history, Clay. How old are you?
45.
What have you been doing for the last 45 years?
I used to be a professional fighter. I used to be a pro boxer.
So what age?
I retired quite early, about 29. I was managed by Mancini and Mickey Duff. I was the second best boxer in Great Britain. I had over 100 fights and I come second in every one.
Do we get the joke? Yes.
Charming the Dragons is a good start, but now Duncan Bannatyne wants to get down to business.
What does it cost to make an AbsPack?
£3.25.
Okay, what do you sell it? Apart from the fact that you can strap it on, you've got it on all the time, what's the advantage to that as against using the rolled up towel?
It's like between using a skateboard and a car. If you get in the towel, you've got to roll it up. The thing about a towel, after a few sit-ups, it loses shape. This will never lose shape.
And you pass it to me?
Yeah. Fits all sides.
So what's in it?
Foam.
Foam.
Foam rubber, yeah.
What patents have you got?
Okay, there's no patent. All I got is trademark.
So it kills it, really.
I don't agree. I know what you're going to say, anybody can copy it, right?
Yeah.
If you're telling me, if anybody can copy it,
Yeah.
you're saying to me this is a decent product. That's the way I see it. Secondly, what are you going to call it? Abs belt? That's already taken by another company who's doing completely something different.
Ab strengthener. So many names.
No. AbsPack. Come on.
Clay's belief in his invention is clear, but is it misguided? Deborah Meaden wants to know.
Clay, when it boils down to it, you have no protection on this. So the only thing that you're really selling is the name. You're asking for an investor to value this name at £200,000.
Great name.
Clay, I know you're hanging off AbsPack, because
you do love it, but honestly, abs, belt, lots of different variants. I do think it's so easily copied, and I can't see how you could make a lot of money out of this.
Can I tell you who I'm talking to at the moment? I'm in early talks with the MOD, the Army boys. They have tons of stuff flown out. ASPAC goes on their kit. Tell you what, that in camouflage, mustard. Then, no, hear me out. Army boys, you imagine it, they can get down any time.
Clay, it's been a great experience. It's been good to meet you.
So you're out of here?
Unfortunately, I'm going to have to say I'm out.
It's a first taste of reality for Clay as he loses his first dragon, and it doesn't look like Theo Paphitis is about to let him off the hook either.
If this got on the shelves, I'd buy one. As you say, just strap it on, no messing around, not doing my neck in. It's probably good. The problem is, how do you make money from it?
Sell lots of them. I think that we can sell 20 million of them worldwide.
Could we? And Reebok wouldn't want to sell their version. Adidas want to sell their version. Nike sell their version.
The market, I don't have to tell you how big the market is. AdsPack's the original and the best. AdsPack.
Look, I hear what you're saying. Problem is, I don't think you would sell enough of these to get my £50,000 back. And for that reason, Clay, keep fighting, but unfortunately, I'm out.
Clay, you've done the classic entrepreneurial thing, which is come up with a problem, come up with a solution. So far, textbook, brilliant. But it could be copied faster than we could physically get it onto the shelves. So I won't be investing, I'm afraid. Thank you. I'm out.
2 more dragons out, and Clay's confidence is ebbing away. Duncan Bannatyne knows this market well. Has he seen something that his rivals have not?
Clay, we sometimes say things like this. If I had an implant product, it's not an 18 implant product. Well, even if it was, you can't protect it. There's no way you can protect it. So that
Don't you think the market's big enough?
No. So reluctantly, I'm sorry, but I'm out.
Thanks for the opportunity.
I think you've had it all, and I don't really think there's any point in reiterating it. There's just no investment opportunity here.
Yeah.
No, and I can see
I appreciate this.
But I've got to be honest with you. I've got to tell you the truth. And I think you've just got to be a bit more innovative and think of something else, and then come back next year. So I've got to say, I'm out. But good luck.
It's hard to take, but cruel reality of it is I'm hearing you. I've got to take that on the chin.
Cheers.
Thank you.
Take care.
God bless. Thanks. It's been emotional.
Lessons learned, perhaps, but no cash. Clay leaves with nothing.
What a great character. He's the kind of salesman that you need in the company, isn't he?
Absolutely, yeah.
Okay, so experienced innovator comes in, tries to sell the idea of the product, try to get investment, and the fact that he doesn't have a patent protection is key, because with patent protection you can prevent somebody having a very similar idea, coming up with a similar product, and if that happens and you have a patent protection, then you can sue for patent infringement in a way you can't with just, of course, a trademark protection. So the question about patents is key on, well, it's not key in the software industry. So we've established that copyright is the main way to protect software. What is the situation regarding patents. From the point of view of the software industry, you would want to have patent protection, right? Because it's more protective. It prevents people from reverse engineering to a large extent, or for coming up with similar ideas, similar processes. And so, from the point of view of the software developer, you would want to have patent protection. What are the limits to the patent protection you can have regarding software? From the readings, I don't know if some of you went into in the essential reading, they tackle this notion of the patentability of software and what's the outcome, basically. What's the view towards the patentability of software? Is there a difference between different jurisdictions? What's the situation in the US, the biggest market for software, where most of the software comes from? Is there a difference between the EU, with the UK? Can you protect software with patent? Again, if you're a software developer, you might want to be able to do that. Yeah.
In the UK, was it kind of like they were sort of seeing it as software was like this business process or a sort of like intellectual understand it, and so therefore they wanted to exclude it from being able to be patented?
Yes, so the general rule in the EU, in Europe, is that you can't patent software as such. Okay, so you can't have a piece of software that's just only software and that you can patent that. So that's excluded subject matter. So the rule is that. Now, in practice, so it means also that if you have an invention that uses software, the software can be protected within the context of the invention. So if you have, if you have an invention that uses software, you might be able to get protection for that software if it's essential to the way the invention works. Okay. So that's the kind of the general rule. Software cannot be patented as such. Now, of course, the whole difficulty is, what do we mean by as such? And in practice, we've seen that generally speaking, again, broad generalization, the US is a bit more amenable to the patenting of software. So you will see a lot of software in the US in licensing agreement where it says this is patented and copyrighted. But even in the US, there's a bit of pushback against this patentability of software. Okay. In Europe in general, it's even less easier traditionally to get patent protection for software, but we've seen a move towards so it's changing. So basically, if you have one thing to remember, that patenting for software is complex. Okay. Generally, no, you can't, but you might be able to in certain circumstances. So it's something that is more tricky. That's why we're not going to focus on that. So I mentioned it in this class, so then we could say, yeah, it's too complex. If you want to look into it, you can look into the further reading. It's a complex topic, but it's just to say we're not going to discuss it further in this course. Okay, so we're going to focus on mostly copyright, and also the other one that is kind of relevant, which is not an IP right as such, is the trade secrets confidentiality dimension. So I ask you to look at trade secrets. So what are trade secrets? How are they different from other IP rights? In which setting will you be relying on trade secrets confidentiality to protect your IP. I mean, it's not the right term, but protect your software, the way it's made, the way it's been designed. What are the benefits of confidentiality? What would you say is the main feature of other IP rights in terms of the trade-off? Yeah. Publicity, yes. So that's the main feature of all the IP rights, is you have to make them public to get protection. You know, when you apply for a patent, the patent, so you have to explain what the invention is. You have to get the patent, and then the patent is published, you know, in an openly accessible database. Okay, so everybody can see what your invention is, right? Then you get strong protection, right? But what's the drawback of this publicity? So what is the drawback of having, you know, publicizing your invention, the details of your invention, and what benefit it has? Conversely, why would you choose not to do that?
Can someone get a feel from the way you invented something and mimic that to produce a different product in the same way, and then use your invention?
So if you are a very innovative company, you publish patents, you have your competitors that are, of course, they wouldn't be able to reproduce the exact same invention. It would be, because it's protected by the patent, but they would get a lot of information about what you're working on, about your research, about the way you've solved this issue, and all that information is really, really valuable for them, for your competitors. Okay, to know how you ended up with this particular product. So it's a trade-off when you patent, when you copyright. You have to, or trademark also. In trademark, what is the risk in putting a trademark out in terms of your competition? I don't know if you guys are into following in what field. In mobile phone, there's a lot of risks linked with the granting of a trademark. Companies are becoming more and more careful. What is the risk for in any kind of field innovation? Yeah.
That it becomes a common world, no more distinctive.
There's that risk, but also in terms of so that's when the world becomes so successful, right? Used so much that it loses its distinctiveness. But at the very start of the process, when you are, innovating, about to launch a product, yeah,
you lose secrecy.
Yes, you lose secrecy. So because it takes time, and also it's something that I haven't mentioned, but to get a trademark or to get a patent, it takes time, right? But when you apply for a trademark or patent, that is public information. So if you're working on a product that you are about to sell on the market, you have to apply for the trademark ahead. Okay? And your competitors might be watching what Apple trademark applications are. Okay? So there's always a trade-off, a risk. And so people who follow mobile phone developments are looking at the IP office around the world to see what kind of trademarks application and of course patent application. And you could kind of almost predict what's going to happen in 2 or 3 years' time by looking at the application. So much so that what is the if you think in a paranoid way, think about being paranoid or Machiavellic, knowing that, your company, you know that what you apply, if you apply for a patent, a trademark, people will watch what you're doing and try to figure out what you're doing. What's your strategy, what your product, what would you do? Something that happens quite a lot. Yeah?
File a lot of different patents and kind of a range of things to cover what your actual idea is.
Yes. It's kind of a information overload, so you file patents for stuff you know that you're not going to use. You try to flood the system with information that can misdirect your competitors. Okay, so that's one strategy that happens. So there's a trade-off between all that. And that's when trade secrets become useful. So one is when you cannot obtain IP protection. So for a lot of stuff, discoveries, algorithms, they cannot be protected by any of the IP rights. So you have to rely on secrecy. Okay. A lot of the protection for secrecy happens because before you have an IP right or even a potential claim to IP right, so at a very early stage of an innovation, it cannot be protected yet, and so you want to rely on secrecy, especially within a company, within a group of people. And when you collaborate with different people, especially from different organizations, you want to rely on secrecy. And as we've mentioned, the other option is you could obtain IP protection, but you choose not to, because there's too many risks in disclosing the information. Right? So it's not worth the risk of getting a patent and giving up too much information to your competitors. So these are the kind of the two main examples of the use of secrecy. Do you have some examples of products, services that are mainly protected by secrecy? Yeah.
Like the Coca-Cola recipe?
Yes, the Coca-Cola recipe is one of the famous one. In the tech field, what is possibly one of the most valuable secrets. Yeah.
The Google algorithm?
Yeah. Yes, the Google algorithm. So I'll put the slide for the Coke. Also, I think Iron Brew has secrecy. So a lot of recipes, sauces, and different food stuff. But in the field of tech, the Google algorithm is really shrouded in secrecy, and you have a lot of protection around that. Quickly, so trade secrets, for a long time it was mostly judgment law. So, and then in 2016, the Trade Secret Directive was adopted and then implemented within a few years across the EU, including the UK. Okay, so you have provision in the UK regulations 2018. So this secret information that has commercial value, and then you have to prove that to be able to protect it, you have to prove that you have made steps within your organization to protect this information. So you have some criteria about how to get protection, and then if there's a breach of that, you can litigate. How would you establish as a company that the information is confidential? Because that's an element that you have to prove your claim that you have trade secret protection. What kind of steps would you
sometimes to write some NDA.
Yeah, non-disclosure agreement, okay, with your employees or any person you have a contact with. Let's say you're an individual, you want to develop a piece of software or an invention with a company, then you have a non-disclosure agreement. When you discuss prior to being hired, let's say, or to being to go into business or joint venture, you have a non-disclosure agreement. So it's clear that the information that you exchange prior to your the joint venture, let's say, is protected with your employees. Of course, in your employee contract, you have confidentiality. What other type of steps can you take? I don't know how many of you work or have been in touch with law firms. What do you get, which is kind of annoying, but you understand why, what is there? When you get communications from law firms, what is almost always there in your exchange with a law firm, whether you're right or not? There's a disclaimer sometimes. Where do you find this disclaimer? Yeah?
It's usually at the bottom.
Yeah, in the email. You always have the thing, this is confidential information. And another measure you can take is encrypting information. So it doesn't have, the steps doesn't have to be drastic. They can be quite, there's a range of things you can do to prove or establish confidentiality. Okay, what are the challenges? So there's a benefit in having just keeping the information secret. You can put in place procedures. What are the risks? What are the challenges in having that tactic of relying on trade secrets? Yeah?
People being hired by other companies or bribed to reveal information.
Yes. So, people being hired. So, in principle, in your contract, you have some, confidentiality. So, but it's hard then to prove that the edge that the company had when they hired you was not because you gave them information. So that's kind of difficult. But basically, the general risk. So the rewards are huge if you are able to maintain a strong secret, but the problem is if there's just one problem, if the secret comes out, then you lose the protection. Okay, so it's you can sue, but what other, so there's nefarious behavior, there's also more likely incompetence. That's something that happens all the time. So in the UK, we had a few scandals or stuff like people in the NHS forgetting hard drives with all patient data in the bus, or forgetting the laptop, non-encrypted laptop somewhere in the public space. So there's always horror stories. So basically, that is to say that to maintain secrecy in an organization, it's very expensive, very time-consuming. It requires a lot of training from different people. Okay. But trade secrets always good to have it, to keep in mind that is a way to protect, including softwares, especially at the early stages of the development of software. Some of the best basics. Rule of subsistence, we've mentioned that already, but let's have that. So you have to fill in the blank for this. So in UK law, to get protection, it has to be original, it has to be fixed, it has to be one of the categories of works that are listed in the CDPA as being protected. And so I'm asking you, what is the type of work under which the object code and subject code would fall into? So it's not a dramatic work, it's not a artistic work, what type of work would object code and subject code, source code, fall under. Throughout the semester, probably the questions are going to be become a bit more technical. Right? We'll see how that works. It's kind of technical because WooClap it's fun for also the more general cultural knowledge kind of stuff. But whether it can be used for more technical question, I'm going to try that throughout the semester, and we'll see how that works. It's also harder than it looks to phrase the question in a way that is understandable and valid. Okay, do we have more people coming in? Okay, 1 hour, 10 minutes. Okay, let's look at the correct answers. Yeah, so it's protected as a literary work, okay, which sounds a bit, at first, counterintuitive, because we think of literary work as poems, as books and the likes, but also code in itself can be protected. It falls under this category, okay. So the other question I had for you is about the idea-expression dichotomy in copyright. What's that? Why is it relevant to anything to do with copyright, but also in the software world, program world? What is the idea-expression dichotomy, which is at the core of the copyright? Yeah.
Isn't that the actual idea itself can't be protected, but the way it's expressed is protected?
Yes, so, and that's one of the key, kind of difference with patents, which is more like protecting the idea itself, whereas in copyright you can have the same idea in different form, provided that the expression is different, then that's fine. So the protection afforded by copyright is a lot weaker. Can you find examples of, so in the field of literature, let's say, or movies, can you find examples of a storyline, right, a basic storyline, so an idea of a storyline that has been expressed in different iteration, none of those iteration infringe copyright. So give some examples. So these are allegedly all the types of stories that you can make. So it's been identified that there's 20 types of stories. So all the stories that you hear are one of those 20, basically. So it's revenge, escape, love, forbidden love, sacrifice, ascension, dissension. So anything that has been produced falls in within those categories. Okay, now, thinking about forbidden love, can you think of the archetypal idea, story of forbidden love? When you yeah? Romeo and Juliet, okay. So that's that. Romeo and Juliet. Sorry. I was going to ask you what other storylines are based on that idea. I don't know. I have a WooClap question, but it doesn't matter. Can you just tell me what kind of story do you think of movies? Yeah.
Titanic or Brokeback Mountain?
Titanic, Brokeback Mountain, yeah, Brokeback Mountain maybe. What other kind of, well, you have basically two families, so two people from opposing families that have, that don't want them to be together, yeah?
Pride and Prejudice.
Pride and Prejudice, okay. What other idea can you think of? Yeah, I haven't thought about it. I have examples, but they're from 20 years ago, so or more. So I was looking for more recent stuff. Maybe, yeah.
Romeo and Juliet.
Romeo plus.
Romeo and Juliet.
Yeah, I haven't seen that one. The animation. Yes. Okay. No, I haven't seen that one. But I think my kids have. Or is it? Yeah, it's kids stuff.
Yeah.
Yeah. Okay. So I had some example. West Side Story. Okay. Romeo plus Juliet. So an adaptation. Again, very old. Romeo Must Die. What's this one? Scottish one. Again, very old. Most of you were not born, so that's why I'm looking for stuff. Elephant Kiss, about two people in Glasgow, one from Pakistani family, one from a Christian family, so interesting one. Christoph, I had my Jet Li period. So, Fist of Legend, Chinese, Japanese problems linked to that. Yes, so why is that relevant in the software world? This kind of cornerstone of the copyright protection, and why, as we're going to see, is it really important that there is this dichotomy?
The idea of having like a open world game in Los Angeles isn't something you can necessarily protect, but like the specifics of like GTA 5 or something that would be like the actual text of all of the dialogue and those types of things need to be protected.
Yes, so within that, so the video games are quite complex because you have protection of the source code plus everything that goes around it, so any kind of music that is played in the video game has its own protection. But in terms of software, how the software operates, the idea behind the software or what the software wants to do. So for instance, you could have a protection about on the idea of a word processor, right? So Microsoft might want to say, okay, Word is protected, the Office Word is protected, but there is a risk there if copyright would allow Microsoft to have a monopoly on the idea of the word processor. That would be problematic. So this kind of limit within copyright allows for software that do the same thing, but in a different way with different codes, with different source code or different implementation to coexist with an older version. So we're going to detail that in the next two sessions. And also the other limit is whether something is required through technical. We're going to see that next time. Okay. So last question. So for it to be protected, copyright, the work has to be original. What is the originality test? And there are two tests in the UK. There's two tests in Europe. What is the originality test, and what are the originality tests? How do they compare? Anyone want to have a go at that? Yeah?
Originality criteria applies for categories of work. So it's literary, dramatic, musical, and artistic works. So if your work falls within those categories, you have to prove that they are, they have to be original in order to have the copyright in the first place. So the UK test is more flexible. It's essentially you need to demonstrate that you have put some degree of skill, judgment, and labor, and that is established by Ladbroke Football Limited in William Hill. Yeah, and the EU test, there are two key requirements. So the first requirement is that the subject matter must be original in the sense that it comes from author's own intellectual creation, and then the second key requirement is that it must be identifiable with precision and objectivity, and that is called the info test.
Yes, so the difference between the two tests, so you have the UK test is skill, judgment, and individual effort, versus the EU test, the author's intellectual creation. It basically, to show the UK test makes it easier to get copyright protection than the EU test. The EU test has a stronger or higher threshold. But, so which one applies in the UK now? So that's the traditional UK test. Okay, so that's the EU test that has been decided in the InfoPact decision in 2011. Which one, now that the UK is out of the EU, applies? Doesn't make that much of a difference. Complex question. We don't really know at the moment. So the course, yeah.
It depends on the pattern which is used. If it's only one.
No, I mean that's only for copyright. That's only for copyright. Test for for patents is one of the criteria is novel, non-obvious, and so that's different. That's even stronger. Yeah.
And has the EU test not able to cover the table?
Yes. So basically, so far the Court of Appeal have still using, so there was a bit of tension in the UK when the EU test was adopted by the ECJ. The UK court didn't really know how to handle that, and some of them said, no, we're going to stick with it doesn't change the UK test. Others said, well, it does change the UK test. And then the current position seems to be saying, we're going to use that one, but actually there's not that much of a difference. So this is just to draw the attention of one of the key things in IP law is you'll find some of the key concepts are still very much open for debate and discussion, and there's an element of vagueness around it. But we can link that back, the difference between the two, to the core justification of IP. You can see that this version, the EU version, is much more linked to the human rights dimension of copyright, whereas the other one is more an incentive. So the traditional UK one is somebody works, they need to be rewarded for the incentive for their work, and so they need to get copyright. This one is more, yes, what manifests itself is the personality of the author and needs to be protected through that. So yeah, in the Coffinal decision, the ECJ said that the author's intellectual creation, so originality, should reflect the personality of its author as an expression of the free and creative choices, plus it must not be dictated by technical consideration. And we'll see how that last bit, the fact that if you're constrained by technical consideration, what you do might not be considered original. So we're going to see that next time. Okay, so we out of time. We'll do the research and writing tips next week. And yes, so next time a bit more into, we'll dig a bit more deeper into the actual case law, looking at the more technical